She's so fine. Helluva blows my mind. Helluva lights my day.
What's good, guys? Today is Thursday, November the 10th, 2022. I want to say something special at the beginning of this. Today is the birthday of the Marine Corps, and my grandfather was a United States Marine gunnery sergeant, pistol expert, and marksman, and I just wanted to wish them a happy birthday today. And this will be part 4 in the complaint, the initial complaint filed in the Kenneka Jenkins case, and we're just going to pick right up where we left off. 71. That, as a direct and proximate result of the above described actions, plaintiff's decedent Kenneka Jenkins and her estate suffered damages including, but not limited to, and it's the exact same damages that they are alleging from the hotel: conscious physical pain and suffering and death, severe emotional injuries, mental anguish, mortification and humiliation, embarrassment and denial of social pleasures, economic loss, including wage loss, medical expenses past, present, and future, exemplary damages, punitive damages, attorney fees and costs, loss of love, society, and companionship, reasonable funeral and burial expenses, loss of gifts, gratuities, and other items of economic value, and all other damages allowed by law. Defendant Caddyshack Restaurant is vicariously liable under the doctrine of respondeat superior for all negligent acts committed by their employees and or agents when acting within the course and scope of their employment. Wherefore, plaintiff respectfully requests that this honorable court enter a judgment in favor of the plaintiff and against the defendant in excess of $50 million, exclusive of costs, interest, and attorney fees. The doctrine of respondeat superior is also referred to as vicarious liability. It identifies that the organization is liable for the negligent behavior of its employees as long as the employee or volunteer is acting within the scope of their responsibility. And I want to show you this example of vicarious liability. If a mechanic fails to properly repair the brakes on a car, and the car is then involved in an accident because of its faulty brakes, the mechanic could be responsible for damages. The mechanic's employer could also be held liable because the employer has a responsibility for the negligence of their employees and the work or duties that they perform. And one more little graph, hoping that it'll explain it a little better. Party A supervises the actions of Party B. And when Party B is behaving in a way that's unsatisfactory or negligent, Party A is then held responsible for that legally. So that's what's happening in this lawsuit. The Crown Plaza, F&F Realty, CPO Hospitality, Capital Security, they're all being vicariously liable for the actions of their employees and or agents acting on their behalf. So it becomes very important who is an employee of who, okay? And I spoke about this in another video because the assistant food and beverage manager said that he helped out security sometimes. But that to me was a strange statement because either you are on the clock for the Crown Plaza as the food and beverage manager, or you are on the clock as a security guard for Capital Security. It's one or the other. It can't be both. You see what I'm saying? So whoever he was on the clock for is going to be held responsible for anything that he did that was wrong. Okay? Just like all the other employees that were negligent on down the line from the beginning to the end. And for those that caught the update of what's currently going on in this case, I said that Capital Security looked like they were getting hammered. And there's a reason for that. And we're about to get into those reasons. But these counts are exactly the same counts that Miss Tereasa and her legal representation are alleging against Crown Plaza, against Caddyshack. It's just now worded towards Capitol Security. So I'm just going to go over, I'm going to read these because we've already explained to them in detail what they each mean, and that might save us a little bit of time. 73. Plaintiff's decedent re-alleges and reasserts all previously enumerated paragraphs as though fully set forth herein. Number 74. At all pertinent times herein, defendant Capitol Security owed a duty to provide security services and maintain a safe premises at Crown Plaza Defendant's Hotel. 75. At all pertinent times herein, defendant Capitol Security was in the business of providing private security, loss prevention, and investigative services. So what that's saying is that Capitol Security was employed to provide private security, loss prevention, and investigative services. Should something happen, they were responsible for investigating that act. 76. At all pertinent times herein, defendant Capitol Security was the exclusive provider of security services on the premises at Crown Plaza Defendant's Hotel. So they were the only company that was providing the security services there. 74. At all times herein, at all pertinent times herein, defendant Capitol Security voluntarily and or contractually assumed a duty to protect the premises, the general public, its business invitees, guests, and plaintiff's decedent Kenneka Jenkins in particular on the premises of the Crown Plaza Defendant's Hotel. So they were under contract to protect the property, the general public, anyone they invited there for business, guests, and specifically Kenneka Jenkins. Number 78. At all pertinent times herein, defendant Capitol Security voluntarily and or contractually assumed a duty to protect the general public, its business invitees, guests, and plaintiff's decedent Kenneka Jenkins in particular from the criminal acts on the premises of the Crown Plaza Defendant's Hotel. So that makes it more specific. They were specifically under contract to protect the public, business invitees, guests, and specifically Kenneka Jenkins from any criminal acts going on that hotel property. That was an epic fail, wasn't it? 79. At all times relevant hereto, defendant Capitol Security owed the business invitees, guests, and plaintiffs decedent Kenneka Jenkins in particular a duty to exercise reasonable care to ensure that services voluntarily undertaken by their agents and or employees were done so in a manner so as to not inflict injury upon others. So there's where they're getting into this liability. The people employed by Capitol Security had a duty, a responsibility to exercise care to make sure that the services they provided did not inflict injury on anyone. Number 80. At all pertinent times herein, defendant Capitol Security owed a duty to the general public, its business invitees, guests, and plaintiffs decedent Kenneka Jenkins in particular to properly supervise, train, and hire its agents and or employees who were working at the Crown Plaza Defendant's Hotel. Just like they alleged regarding the Crown Plaza and also regarding Murray Brothers Caddyshack. They are under a responsibility to properly supervise, train, and hire people to work there for them as security. That's their job. 81. At all times relevant hereto, defendant Capitol Security owed a duty to their business invitees, guests, and plaintiffs decedent Kenneka Jenkins in particular to maintain policies and or procedures so as to prevent injury upon others when undertaking a duty to act. So Capitol Security had a responsibility to prevent injury from happening when they were called to action. So anytime they were asked to act on something, they had a duty to protect their guests, business invitees, and specifically Kenneka Jenkins in that process. 82. At all times relevant hereto, defendant Capital Security owed a duty to their business invitees, guests, and plaintiff's decedent Kenneka Jenkins in particular to maintain policies and or procedures so as to prevent injury upon others when agents and or employees voluntarily undertake a duty to act and or to protect the premises patrons. So what they're saying there is Capital Security had a responsibility to maintain the policies and procedures to prevent injury when the employees or someone acting on their behalf voluntarily stepped in to do something in regards to a guest, business invitee, specifically Kenneka Jenkins, or someone else who was on their property at the Crown Plaza. At all time, number 83. At all times relevant hereto, defendant Capital Security owed a duty to their business invitees, guests, and plaintiffs decedent Kenneka Jenkins in particular, to maintain and properly observe security and or surveillance footage so as to ensure the safety and security of others and prevent injury upon others. That's pretty self-explanatory. They had a responsibility to review the surveillance footage to keep people safe and free from injury. I don't know why it keeps doing that, but it's all good. We'll get right back where we were. 84. At all times relevant hereto, defendant Capital Security owed a duty to their business invitees, guests, and plaintiffs decedent Kenneka Jenkins in particular to maintain and properly observe security and or surveillance footage when voluntarily undertaking the duty to do so. Again, pretty simple stuff there. They had a duty to maintain and properly watch the security and surveillance footage. Then it gets into 85. Defendant Capital Security was negligent and or grossly negligent and responsible for. And it lists things. And these are the things that they are going after Capital Security for being negligent with. Failing to secure an area otherwise inherently dangerous. Failing to timely review security cameras when undertaking a duty to do so. Failing to hire, manage, supervise, and train employees and or agents who were competent to deal with missing persons in a reasonable manner. Because they dropped the ball on that one. They did not know how to handle a missing person on their premises. Let me rephrase that. On the premises they were supposed to be securing. Failing to hire, manage, supervise, and train employees and or agents who were properly trained not to negligently disregard dangers to the general public. So in other words, they needed to have people who were competent to look at a situation and say, hey, that's dangerous, and we need to warn the public, and we need to fix this. Failing to hire, manage, supervise, and train employees and or agents who were competent, period, who had the sense God gave them. Failing to hire security personnel who are competent and capable of acting reasonably under the circumstances. Failing to adopt proper procedures and policies for their employees and or agents. Failing to enforce existing policies and procedures to prevent the conduct described herein, and or failing to promulgate sufficient policies to prevent the occurrence alleged herein. Failing to properly and adequately train its agents and or employees with relation to safety procedure, and other acts of negligence and gross negligence and reckless conduct to be discovered. Now that last phrase there is to catch everything else. It's a safety net so that they can catch anything else that comes up within this trial or discovery process will fall in that. So any other acts of negligence or gross negligence that they didn't mention here that may come up along the way, they can also accuse them of that as well. So basically the same stuff that they alleged against the others, as well as not hiring people who were competent to do the job and keep people safe. And that was their sole purpose there, really. 86. At all pertinent times, Defendant Capital Security had a duty to act when they were put on notice of plaintiff's decedent's disappearance and were contractually obligated to act and or voluntarily undertook the responsibility to act as existed at the time. So when Kenneka went missing in their hotel, they were obligated to undertake the responsibility to find her. That was their job, contractually their job. 87. Had employees and or agents of Defendant Capital Security checked the security and or surveillance footage when they undertook the duty to do so, they would have found plaintiff's decedent Kenneka Jenkins in a timely fashion and prevented her death. Simple stuff there. They allege the same thing about Crown Plaza. 88. Had employees and or agents of Defendant Capital Security maintained careful watch of their security and or surveillance footage, they would have noticed plaintiff's decedent Kenneka Jenkins visibly disoriented, distressed, and lost, and been able to prevent her from entering the abandoned kitchen and thus prevented her death. 89. Had employees and or agents of Defendant Capital Security properly intervened when they observed plaintiff's decedent Kenneka Jenkins visibly disoriented, confused, and lost within their premises, they would have prevented her from entering the abandoned kitchen and prevented her death. Had they jumped in and when they saw her stumbling around, they could have prevented this whole thing from happening. Number 90. As a direct and proximate result of the negligence of Defendant Capital Security, plaintiff's decedent Kenneka Jenkins was seriously, painfully, and permanently hurt and injured as her body shut down and she froze to death. Remember, they are operating off of the paperwork that the medical examiner provided them. And that's what that paperwork said. 91. That as a direct and proximate result of the above described actions, plaintiff's decedent Kenneka Jenkins and her estate suffered damages including but not limited to, and it names the same damages that they listed for Caddyshack and Crown Plaza, and I'll just read over them. Conscious physical pain and suffering and death, severe emotional injuries, mental anguish, mortification and humiliation, embarrassment and denial of social pleasures, economic loss including wage loss, medical expenses, past, present, and future, exemplary damages, punitive damages, attorney fees and court costs, loss of love, society, and companionship, reasonable funeral and burial expenses, loss of gifts, gratuities, and other items of economic value, and all other damages allowed by law. 92. Under Illinois law, Defendant Capital Security is vicariously liable under the doctrine of respondeat superior for all negligent acts committed by their employees and or agents when acting within the course and scope of their employment. And that's what I spoke about at the very beginning. How in this instance, Capital Security is responsible for the negligent acts performed or lack thereof of performing in regards to securing the premises, guests, and especially Kenneka Jenkins. Wherefore, plaintiff respectfully requests that this honorable court enter a judgment in favor of the plaintiff and against the defendants in excess of $50 million, exclusive of costs, interest, and attorney fees. And I'm going to end it right here and pick right back up in part 5. And I think we're getting close to wrapping this series up. So I'll see you guys in the next video. Thanks for watching.